Hard Facts and 92.3 Nigeria Info. Good afternoon. My pleasure having you on the other side of the radio. It is time for us to switch conversations. This time I've been able to get across to my guest. He is a professor of law at the River State University. I will introduce him shortly. But yes, we want to continue a conversation we started sometime last week. There was another lawyer on the show that on that day, and he talked about a Facebook for the extension of local government chairmen's time in office. It is not practicable of elections to be held. Last week, had a lawyer say that means the likes of T.D. Lloyd, the likes of Samuel CK are still in charge of the local governments, saying that the led assembly did the right thing by putting in place that law. But let's welcome Ritchard Wokocha, Esquire, Professor of Law, River University. Have you? It's good to show. Wow. What's that?
Hello, and good evening, Nigeria.
Right. So to my very first question, what do you make of that part of send that except I don't know if you've gone through it. What do you make of that announcement by the Supreme Court saying local government chairmen can have their tenure extended, if it's not practicable to hold elections?
First, to observe that I have an opinion expressed by one of the justices. I am sure that you did not find that same opinion as a point of decision expressed by all the other justices.
Okay.
So first, it was an opinion. One of the justices of the Supreme Court who presided over the case was expressing his opinion on what he thinks is possible, going by what is contained in Section 135. But the first thing about the written constitutional system is that whatever the Constitution did not say cannot be read into the Constitution.
Okay.
In other words, you cannot stretch what the Constitution says in one place and assume that it is applicable or can be applicable to another place. Otherwise, President Obasanjo would have succeeded when he declared the office of the Vice President vacant by reason of the fact that he had abandoned the party on whose ticket he was elected as Vice President. A written constitution is specific and deliberate. It states what it wants to state, and when it has done so, you cannot stretch it, you cannot reduce it. So, first, I think the entire rule of the law, and even that exercise, with due respect to the Supreme Court justice, I think that all of that line of thinking and impression was unnecessary.
Okay.
Look at Section 7, subsection 1. It tells you, and you will recall the first time we had this discussion on extension of tenure. You will recall I told you that looking at Section 7, subsection 1, the House of Assembly of the State has responsibility, duty, and power to determine how the local government system runs.
Okay.
So long as what is guaranteed by the Constitution, that is democratic election, is there. The rest of what happens in periods of interregnum, what happens in any other period, that no other law provides for, and no other law can provide for them, except the House of law of the House of Assembly. Because local government is local affair of the state. It is to be created by the state. It is to be, everything about it is to be determined by the state, subject only to democratic process of election of its leadership. So, I made it clear to you by Section 7, subsection 1, it is within the power of the House of Assembly to determine what happens in periods of interregnum, such as a period when elections are not hold. But even then, if you read the expressions of the justice who gave that impression, he said in times of war or something, he mentioned another thing similar to war. So, are you going to extend that to in terms of inconvenience? Does it mean that if something happens on a particular day and what is to be done cannot be done on that day but can be done on the following day? that we will need to extend the power of the tenure of the president or that of the governor by 6 months. No, that is not the intendment. So in law, when a number of things are mentioned as examples, they are in a class. It is only a thing in that class of events that will justify the action that is talked about. But as I have said, Section 7 subsection 1 is the relevant section here. There is no need to interpret another section and imagine that it is possible to apply it today. There is no need for that possibility because Section 7 subsection 1 provides for the power for that action to be taken. Where there is a written constitution, there is no room for...
So what is additions?
In the context, yes.
What is read?
Okay.
Now, the next question would be, has this said it was just an example? Does this affect many? Was once Martin Metami posted it on Twitter, claiming
it doesn't advance this in any way. You will recall that even at the date of that judgment, I think it was reported that up to 21 states.
Yeah, 21.
We are at that moment. Yes, we are at that moment operating with caretaker committee, which was provided for by their laws, as well as the law of Rivers State. Now, you will recall on our first discussion of this matter when the issue of extension of power. I told you that the question is not so much whether the House of Assembly can, but whether what you are talking about is an act of the House of Assembly of Rivers State, considering that it is done by men who have, according to the Constitution, Section 109 of 1, as perfected by the events that we are taking in consonance with Section 2. Men who have vacated their seat. And I ask whether there is a valid amendment law in the light of that development, in light of the persons who purportedly made what you were referring to.
Okay.
You recall that was what I told you at that time.
Okay.
It's not a question of whether a house can, but whether a house has.
So let me understand you, Prof. Let me understand you, Prof. So let's come to River State situation and let's assume that the Martin Amaewhule led assembly is the legal assembly. Does it mean that it can extend the time in office of the ex-local government chairman? Is that what you're saying?
The House of Assembly of Rivers State, like every other House of Assembly of State, has the power to determine what happens in the event that the election does not hold. National Assembly cannot. The Constitution did not provide for it. It committed it to the House of Assembly of State.
Okay.
So the House of Assembly of the State can do so. Just the way the Constitution has provided in the case of national government and state government, what shall happen in periods of interregnum.
Okay.
The House of Assembly has legitimate power to do so. And I tell you, the Rivers case, when applied to Rivers State and the subject we are discussing, is the question whether House of Assembly of Rivers State has taken any action. Okay. Whether the law of 2018 has changed.
Okay, but then again... Sorry, I'm interrupting. I do have a commercial, so I need to throw this question at you quickly.
Okay.
So, but we remember, the High Court judge, Judge Q, had given the ruling that it is unconstitutional to extend, the ex-chairman's time in office. So, is that not some sort of confusion for non-lawyers like me?
That's another question. Now, the judge was of the opinion that doing so, remember that providing for a period of interregnum is providing for it to be a regular action.
Okay.
And the court said that any form of government other than one that is democratically elected, and you recall that the Supreme Court in this judgment from which you expected this expert emphasized the same thing, that nothing short of a government or democratic election is valid.
Okay.
And the High Court held that same opinion.
All right.
And said by implication that any other form of appointment, whether by the executive or by the legislature, amounts to an imposition on the sovereignty of that local government and not an act of that democratic action of that local government. That was the position that court took. It is the same position the other justices took in the Supreme Court matter.
So there is nothing to celebrate just yet for the Martin Amaewhule-led assembly.
No. There is nothing. There is something said by the way, by the side. It's not a decision. There are judicial processes that will commence on the River State case.
I do have a commercial. Sorry, Prof.
They are at liberty.
Prof, Prof, I do have a commercial.
For more talk, news and sports, stay tuned to 9.
Right, the headline news: military issues warning to end bad governance, protesters hoisting foreign flags. Police arrest suspect producing Russian flag in Nasarawa state. Government declares 24-hour curfew as rioting continues in Kaduna communities. President Tinubu, security chiefs in closed-door meeting amid protests. Governor Fubara signs order to establish investment promotion agency. Court stops sale of Nigeria Air to Ethiopian Airlines. House of Representatives dissolve committee investigating adulterated fuel import on the foreign scene. U.S. military completes withdrawal from key drone base in Niger. Details in the 6 p.m. bulletin. To reach the news team, send an SMS or WhatsApp to 0808-721-7215. I am Kalada Kurubatable. Conversations with Professor Ritchard Wokocha continues to stay tuned.
This is Hard Facts.
All right, it is the bottom of the hour, 5:30 p.m. Yes, you're listening to Hard Facts and 92.3 Nigeria Info. With me on the show is a professor of law at the River State University, Professor Ritchard Wokocha Esquire, and we have been talking about a conversation. I mean, we completed a conversation we started sometime last week. The Martin Amaewhule led assembly saying it is victory for them based on an accept of the Supreme Court judgment on local government autonomy that I know talks about extension of the time of local government chairman by the assembly, saying just like the National Assembly has got the constitutional right, it is believed that the House of Assembly has got the same. And my guest, the Prof, is saying that, once it is written, or it's a written constitution, we do have unwritten constitutions like in the UK, but once it is a written constitution, you cannot add, you cannot subtract. And he also did say that it's not even a matter of whether the House of Assembly can or cannot. The House of Assembly can, but it's the argument in his own perspective is the legitimacy of the assembly making that law. And so we're back to the very beginning of that argument. I don't know what your thoughts are. So just before the break, I was asking the Prof, so it is not celebration yet for the Martin Amaewhule-led group. But let's take a listen to what Godspower Egbule did say on Friday as it relates to this conversation.
First of all, Mr. Kalada, let me say that I have made comments before that the public confidence in the judiciary is diving, and I make such comments taking cognizance of what's happening in Rivers State. Let me say this, and I'm saying it with every element of the people. So much has been done in the Rivers State judiciary, and the judiciary, one way or the other, needs to sit and make sure that the public confidence that has nosedived is one way or the other remedied. You see, when a court wants to interpret the actions of the House of Assembly, it does that with respect to looking at whether the act of the House of Assembly is unconstitutional. No judge has the right to just, in his own discretion, nullify a law made by the House of Assembly if that law is not unconstitutional. If you say the law is unconstitutional, the Supreme Court has said you must cite the section of the Constitution that you think the law contravenes. So if you say the local government law...
Are you saying... Okay, so he was, referring to Justice Kyo's judgment, and he said, see, the Supreme Court has said it, and he agrees, and he thinks that, Chidi Lloyd, Dr. Chidi Lloyd and others whose time expired in the month of June can still be set to be in charge of the local government. All right, welcome back, Prof. It's good to have you on the show.
Thank you, Corrado.
All right, so I was just asking, is it Uhuru yet for the Martin-led group? Just before the commercial. So let's get your thoughts, please.
It will be Uhuru the day a court of competent jurisdiction set aside the implementation of subsection 2 of section 109, which gave effect to section 109 sub G, under which their case falls. As you and I speak today, no such action has taken place.
All right.
None.
All right.
Yes. When the Constitution provides for things that are to be done, especially legislative action, there is no action that is beyond the shade of the court or the powers of the court to determine whether a thing has been validly done or not.
Okay.
But a legislative action is a legislative action.
Okay.
And once taken, it has its effect until a court overturns it. So I think what has been going on in our state is the presumption that we can run foul of protection that has been activated against us according to the Constitution, and we say we don't agree, it is not yet done until a court does it. The Constitution does not say it should be done by a court. The role of the court in Section 7, Section 272, subsection 3, the role of the court there is to answer the question whether the action has been validly done. In other words, whether it should not be set aside for not having been validly done. So we don't insist that this is where we are. Once the Constitution is implemented, it is implemented. You will need a court to set aside that implementation.
Okay, Prof. I do not know if you came across the news last week that Martin and his led assembly, or the members of that assembly, did participate in the PDP World Congress, trying to give the picture or the idea or an opinion that they're still PDP members. Does that in any way affect all of these arguments?
You can leave a party and go back to the party if the party graciously accepts you. You are liberty to do that.
Okay.
Stay within your constitutional right.
Okay.
So if you left the party and for some reason you decided to go back and the party accepted you, you are within your right. The party is within its right. But that does not affect your standing at a place where you are living. Your party has had a constitutional effect. What it simply means is that you can legitimately contest to go back there on the platform of the party which you previously left.
Okay.
And you can carry the flag of that party to go back to the position.
All right then. Okay, I'm going to take calls, Prof. So please, I would ask you to please just stay on the line. But before I go to the phone line, I'd like us to listen to another lawyer, Liboros Oshoma, who is based in Lagos, and this is what he had to say.
So, hello, Kalada. My name is Liboros Oshoma. I'm a practicing lawyer based in Lagos. So, yes, to your question, the Supreme Court has interpreted in that case Section 135, subsection 3. And for the avoidance of doubts, let me quickly read that section. Section 135 says, subsection 3 says, if the Federation is at war in which the territory of Nigeria is physically involved, and the President considers that it is not practicable to hold election, the National Assembly may, by resolution, extend the period of 4 years mentioned in subsection 2 of this section from time to time, but no such extension shall exceed a period of 6 months at one time. So, when the Supreme Court is interpreting this thing, saying that if the National Assembly has power to extend the tenure of a sitting president, so also it customally construes the State House of Assembly also has the power to extend the tenure of local government chairmen, which is what these lawmakers are banding around, because actually that is what they added. That is the section they lifted and added to law number 2 of the Rivers State Administration of Local Government Law number 2 of Rivers State. That is the section they lifted and added to that as a law. So the Supreme Court, in interpreting that section, just says yes, the House of Assembly also can do that, since the Constitution also donates such powers to the National Assembly. But the lawmakers have forgotten that in this section it says if the Federation is at war in which the territory of Nigeria is physically involved, and the President consider that it is not practicable to hold election. The question you will now ask, we are now placing it and bringing it to bear in the case of Rivers. Is Rivers State at war? Is it impracticable to hold election in Rivers? Is Rivers State involved? Is the territory of Rivers State involved in the war? As the governor had it impractical to hold election. So, like I said, the law says the president considers it not practical. So if you apply it to Rivers State, it is considered to extend tenure of local government chairman. So the State House of Assembly cannot on their own sit down and just extend the tenure when there is no such request from the governor. Also, the state cannot do that if these ingredients are not there. That is one, the River State is at war, and then the territory of River State is physically involved in the war, and then thirdly, the governor considered that it is not practicable to hold election. So this section does not just apply blanketly. The ingredients must be present.
Prof, quickly, do you agree, with the statement by the Lagos-based lawyer?
Of course, you recall I told you that the Constitution, in the case of Section 135, outlines circumstances in which it is to apply, and I said you cannot extend it to other things. It has to be things of that category that will justify such action. And of course, I also agree with Labour completely. The fact that the Constitution says it is the chief executive that is to consider it impracticable for election to be held. Impracticability of election holding is not the same thing as possibility of election impracticability of the hold attending. It's in tandem with what I said earlier.
All right, then let's go to that. To extend the tenure of local government chairman. But what are your thoughts now? Having listened to two lawyers on the show today and a lawyer on Friday, it's time for you to tell me what you understand, what you think about this issue. What I do understand right now is that it boils down, one, to the legitimacy of the House of Assembly, and two, it is the governor that defines whether it is practicable. I'm there again. I almost stumbled on the word on Friday. I'm there again. It's practicable.
Not legitimacy of the House of Assembly, but legitimacy of the persons, the actors who purported to be acting as House of Assembly at the time of
that is what is in court. So that's what I meant by the legitimacy of the people who are. I take the correction there. So I'm going to the phone lines now. 0817 923 0002 and 0817 923 0003. WhatsApp number 0809 030 6416. Please be reminded, we do have a call screener. She will take down your name, take down your location, pass it through to me, or patch it through to me, and I will take your contribution. So let's be orderly. Let's be concise, and let us be constructive with our contributions. I like that, please. Okay, while I'm waiting for the phone lines, it seems unstable and erratic. Let's listen. This one said, Professor Ritchard said nobody can assume anything into a written law, that the law is the law. But last time Professor Ritchard was on your show, I referred him to Section 106, subsection 1, which recommends forming a quorum before business of assembly can be transacted. I remembered Professor Ritchard made several assumptions in justifying the three-man assembly of Honorable Victor Okujumba. How come Prof is saying today that nobody can make an assumption into the 1999 Constitution as altered? Or is assumption good in one place and same assumption is bad in another constitutional situation of interest? It is also on record that Governor Simfubara months ago referencing impossibility of Rivers State conducting a local council election in the state. Emifiaga. I'll get back to that, but let's listen to Ibi Fubara, who's calling from Port Harcourt. Ibi Fubara, welcome. Let's get your thoughts, please.
Yeah, thank you. Canada. My name is Ibi Fubara. I'm calling from Port Harcourt.
I already know that. I want to get your thoughts quickly, please.
Oh, okay. I greet your guests too. I want to ask a question because I've read something and I saw that the House of Assembly has power to enact doctrine of necessity. So I want to ask you again that in a situation here, the governor refuses to make it practicable, because the House has the power to invoke doctrine of necessity in order to fill that.
I think you already answered that question. It says the House of Assembly of any state has got the power as long as the governor declares it practicable or impracticable.
No. He said something. He said that the governor has the power.
I'm listening. Are you there? Are you there, Fubara? All right. I guess.
Well, I think he was quoting liberals.
Okay.
Because it was liberals who talked of governor's power and all that.
Okay.
But to quickly answer the gentleman who was talking of presumptions, when he made reference to Section 96, I recall that conversation. I referred him to Section 102. I did not presume. I referred him to Section 102 titled Vacancy or Participation of Citizens not to Invalidate Proceedings.
Okay.
Where the Constitution provides, I quote, a House of Assembly may act notwithstanding any vacancy in its membership and the presence or participation of any person not entitled to be present at all to participate in proceedings of the House.
Okay.
And not invalidate such proceedings. I mentioned that if by chance we are not 27 members, it will not bring the House to a halt. Section 102 is provided for that kind of scenario.
All right.
I did not presume. I referred him to a section of the Constitution which answered this question.
All right then. All right. Let's listen to Ida from Inkoro. Ida, welcome. What is on your mind? I'd like to hear from you.
Yeah, tell us that. I want to ask a question.
All right.
Because this is started and asking this question. Now, if this former local government chairman come back, is he under elected, under the caretaker that they are rejected?
It's under elected. Go ahead.
Under which way they are coming back? Is he elected a chairman or caretaker chairman they are rejecting? So, thank you.
All right. I do think if you read that, according to Prof, opinion of one of the justices, it's an extension of elected members. So that answers that. Good news from our three. Welcome.
I greet you, my brother, man.
All right, I greet you right back. Good news. Welcome.
Thank you, then. The Lord, God bless you for always making your time available to educating the public on our ignorance in the law. Quick one.
Let's get to my point.
Yes. It is a straight issue. If it is 1 + 1, 2, it is 1 + 1, 2. If it is not 1 + 1, 2, it is not 1 + 1, 2. Even if the judges may, one way or another, change it, every sound person will go to a court or where they give judgment based on their rules. And when they start giving judgment, if the people who are in charge of the judges deviate from their rules, the sound mind will know. If you have not deviated, the sound mind will know too. So all what the River said, I will quote the former governor when he said that if they don't listen to him, he will fight the present governor. He may not likely win, but he will keep making sleepless nights. So that is what I think is happening. Right. Not because they know that they can go back to that city, it's because they just want to give the governor sleepless nights.
All right.
And then it's good news.
Good news. Thank you. I've got Ben from Outer George. Ben, welcome. I think we'll pause after Ben. Ben, what is on your mind? I'd like to hear.
Yeah, Canada, good afternoon.
Yeah, good afternoon. Welcome.
Yeah, what's on my mind is that every time the Martin Amaewhule led House of Assembly, we always like to assume the power of the governor. And always give constitutional means to do that. What does the Constitution say about the own detection of PDP and APC? Are they not seeing that section of the Constitution? If you defect, you lose your seat. And that's still functioning. This doesn't need court. Every time you say it's court, if you go to court, court will say no jurisdiction, you lack local standing. So I don't think these people are serious.
All right then.
Thank you.
Thank you, Ben. But let's come to you now, Prof. One of the things that Emi Fiaga did say was him making a reference to Governor Fubara's statements, talking about the impossibility of conducting local government. Is that same as not being practicable? Is that a definition of that? I'm wondering. I'm just asking.
No, impracticability is not quite the same with impossibility. A thing can be practicable, but not possible at the time. Impracticability means that it is not possible to practice it. It is not possible to engage in that thing. But impossibility would suggest that there are some immediate difficulties over which it can't be done at the particular moment in reference. You recall I told you there's a difference between a thing being impracticable and I asked the question, what if for a particular reason a thing cannot be done on a particular day but can be done the next day? Will we extend the tenure of governors and presidents in that circumstance? That will not be impracticability. It means it's possible to do that and it's practicable to do it, but not on that particular day. But on the next day it can be done. So when the law uses expressions, it is specific, it is definite. You can just pick up the dictionary and get the clear meaning, legal interpretation or meaning of those words.
Okay. I want to ask a question yet again on assumptions. Assuming that Martin-led assembly is now seen as the authentic, can the ex-chairman be in charge of the local government pending the conduct of election at the local government level? Is that even possible? Because someone asked that question and I felt like I should ask as well.
Yeah, because the law provides for the House of Assembly to determine those matters. If that quote and unquote law number 2 that they purportedly made after they had vacated their seats and their seats had been vacant, if it was done while they were still full-fledged members of the House, it would have been a law of the House Assembly of the State.
Okay.
And if the steps spelled out in that law had been followed, and the governor had sworn those people in, or a judge had sworn them in on the day on the day on which their tenure ended, it would have been all right, because that was contained in the law. Okay. Even if that law does not accord with the Constitution, that's why you have the two expressions, legality and unconstitutionality. The thing can be made according to law or can be done as prescribed in the law, but the validity of that law can be questioned if the makers exceeded their power.
All right.
Or did what the Constitution did not permit.
All right. At this point, I would have to thank you very much, Professor Ritchard Wokocha, Professor of Law, Rivers State University. My time is up. I would have to leave the studio for now so that the news can, come on. But thank you once again for being on the show and for educating us.
Thanks for having me.
All right, thank you, Prof. All right, to you listening, keep listening. In a jiffy, it will be 6 o'clock and it will be time for the major news. But after the major news, we'll continue with the conversation. We will look at the definition of empowerment. We'll look at this conversation, part 2. I mean, this is the part 2 of it. Remember, we had the part 1 on Friday, and I'd like to get your thoughts as we push the conversation for development. And we'll look at possible front page stories for tomorrow. The military is coming out to say, hey, please do not go ahead carrying Russian flag. I thought some of you sent me messages and said there were no Russian flags, but the military has confirmed it. They've even arrested someone who is, manufacturing the flag in Nasarawa State. And so you see, there is the possibility that there may be external factors or sponsors as it relates to the protest. But we'll talk about all of these during the open season. So please do stay tuned. Remember, I am Kalada Kurubatabo. Do follow me on socials. D Kalada, TheKalada. Good afternoon.